Hey everybody, welcome back to the Consumer Warrior YouTube channel. I'm John Skiba. I'm the founder of the Consumer Warrior YouTube channel. I'm an attorney in the state of Arizona. And in today's video, we're going to talk about settling debt collection lawsuits. We'll talk about three things specifically. We're going to talk about the pros and the cons of settling a debt collection lawsuit. We're going to talk about the actual process of what that typically looks like. And then some of the financial and legal responsibilities and consequences of settling a debt is going to be the third thing we're going to talk about. But hey, if this is your first time here to my YouTube channel, please click subscribe, check on that little bell. That way you'll be notified each and every day when we put out new videos that'll help you deal with these serious debt issues. All right, let's talk about debt settlement. Particularly, we're talking about this in the context of you've been sued by a debt collector, the process server, the constable, the sheriff, whoever it is in your state that has sued you. They've come by, they've dropped off that complaint and the summons, and you're thinking to yourself, what am I gonna do? And usually we go to the worst place in our mind and we think, oh, we're gonna go to jail or something horrible like that's gonna happen. Jail's not gonna happen. But there can be some really bad things that do happen if you ignore it, like wage garnishment, bank levy. They can even lien your home in some states if you ignore this lawsuit. So there are different approaches and strategies we talk about here on the YouTube channel as far as contesting it. And sometimes we even talk about like the bankruptcy option. But today I want to talk about settling that debt specifically, where you're offering something less than what it is that they're seeking as a way to resolve it, kind of the pros and cons of that, and then what that looks like, and then what some of your obligations will be if you do settle the debt. Now let's talk about the downside. The downside to settling a debt is pretty easy, is you're gonna have to pay money. Settling a debt means that you're offering to pay them something less than what it is that they're alleging is owed. Now, you may not have the money, you may not have a lump sum, you may not even have a monthly payment, and that's gonna make settlement very difficult, or it's gonna make things super tight for a while you're getting this thing paid off. Not only that, you may have legitimate defenses to it, particularly if there's like an identity theft, if it's something where it's like a junk debt buyer and they haven't really proven that you owe them the specific dollar amount, or maybe it was something where you contested the charges and disputed the charges with the credit card company, but they're still coming after you for that balance. So those are the types of things that are going to be the downside to settling a debt. You're not going to get your day in court, and even if you feel that you are justified in raising these defenses, you're going to give that up if you settle the case. Let's talk about some of the pros. There are some really good positive things about settling the debt collection lawsuit. The first one is that you retain some control as far as the outcome. I always tell my clients, look, when you get sued by a debt collector and you're filing a response and you're dealing with it and you're going against the other side, at the end of the day, the final decision is going to be entered by a judge or a jury, or if you go through arbitration, by an arbitrator. Essentially, the final decision, the power to resolve, get the final decision on this is not in your hands. It's in that of the trier of fact, the judge, jury, arbitrator, whoever it is. And so you give up a lot of control. And even when cases are very good, I tell clients all the time, look, I can't make any guarantees. Each judge handles this a little different. Sometimes the courts, I joke sometimes it's the wild, wild west here in Arizona. And I've had the same judge rule two different ways on almost identical cases. So sometimes it's hard to have a lot of predictability. Also, courts bring their own biases into it. You've got to be aware that in most states, debt collection cases are second only to like criminal or traffic tickets. They deal with these things all day long. Most of them end in a default, and so they're just rubber stamping these things all day long, and they think, this is just another debtor that needs to pay their debts, I'm going to sign off on this. So you deal with all of that when you go forward with litigation. Not only that, the litigation process can be very lengthy. Again, I practice law here in Arizona. I can tell you on cases in our justice court systems that deal with things under $10,000, from the day that they filed their lawsuit and serve you with it until you get a trial date will likely be 10 to 12 months. So you're going to be dealing with this for a year. It's going to be part of your life. Whether you're hiring an attorney, paying attorney's fees, or whether you're representing yourself, this is a year of your life that's going to be devoted to dealing with this and being stressed out about this. If you're in Arizona and you happen to have it in the superior court system, which deals with cases over $10,000, it's likely going to be 12 to 18 months before you're going to get a trial date. So it's going to take a lot of emotional energy. I've had clients come to me and say, look, I feel like I have a strong defense here. Here's what happened. I agree with them. There is a good legal defense, but at the end of the day, they want this thing out of their life. They have other things to focus on. They have family, they have their jobs, they have everything else, and they just want it settled and done. I've even had cases where I'm like, please, let me take this one to trial. This is a great case. They're like, I don't care. I want this done. And I get that. To me, that's a rational, mature approach to this, is that, look, there are things that are pressing other than this lawsuit in my life. I need to get this thing dealt with. And so by settling it, you can often get it taken care of very quickly. So those are the big pros to it. Not only that, but and this kind of goes into our second topic, which is how the process usually works. But you can usually have a lot more input into the resolution if you're trying to settle the debt rather than litigating. So let's talk about the process of how this usually happens. Usually, if you get served with a complaint and the summons, I always say, generally there's no harm in reaching out to the other side and saying, look, I'll settle this, and throw out a settlement offer, whatever it is. In most jurisdictions, if a lawsuit has been filed, the rules of evidence are applicable. And in most jurisdictions, there's a rule, it's usually under Rule 408, that talks about settlement discussions, and usually those discussions in civil cases are not admissible in court. So you can reach out to them and say, look, you're suing me for $5,000. I'll offer to pay you $1,000. I can pay it over 90 days. Here's what I'd like to do, and see what their response is. I usually put a little disclaimer in, because I usually convey these things, whether it's email or written. I usually put a little email in there that says it's subject to Rule 408. You may need to look in your jurisdiction, go to Google Scholar. That's a good place to find these types of rules, but it's usually under Rule 408 in most jurisdictions. That way they know that, look, you can't use this. You can't run to the court and say, oh, look, John Skiba, he offered to pay $500. Clearly he owes the whole thing. They can't do that. I don't see attorneys generally doing that anyway, but you do have some protections, and I don't see any real harm in doing that early on in this case. It's important to understand how the junk debt buyer's attorneys are typically getting paid. They usually get paid on a contingency. That means that they get a percentage of anything that they collect from you. That also means that the more effort and time that they put into this, the less money they make. So a case that goes all the way through trial, that they fought this thing out for the last year, and it's going to trial, the attorneys are losing money on that, the debt buyer is losing money on that, and so you usually get worse settlements if the case actually goes to trial or there's a garnishment or something like that. So if you reach out early on, you may get something quite a bit lower as far as an overall settlement, and if you don't, then you can just file your answer and you can litigate it. But let's say that they agree to it. Let's say that they agree to whatever terms you propose. You can propose a lump sum, you can propose a payment plan, you can propose a partial lump sum and then a few payments. You can get real creative with the type of settlement that you want to do. If they agree to this, before you pay them one penny, you need to submit to them something in writing, or they need to submit you. Usually most debt collection law firms, they will have a letter, often it's called like a settled in full letter, and they will send you the letter and say, hey, here's the terms of the agreement. And once you do that, once you have that, then you can feel comfortable in actually making the payment to the debt collector's attorney or however they want you to do the payment. But make sure you have something in writing. I have seen situations where the settlement is reached, payment is made, but it's never memorialized. You get a new debt collector from that law firm, and they don't recognize the agreement because it was never in writing. Even if it's in an email, preferably if it's in a letter or even a formal settlement agreement, that's what you want to get before you send them any type of money. Now, you may be asking yourself, what if I'm trying to negotiate a settlement? Do I still need to file an answer? It's a good question. I always say when you get served with a complaint and a summons, look on the summons and see how much time you have to file your written answer with the court. In Arizona, you have 20 days. In other jurisdictions, it's 30 days. Some jurisdictions, it's 14 days. So look at your summons, put that in your phone, put a reminder that you need to file an answer on that date. If you're trying to negotiate it and that deadline is coming up, if you don't have an extension from the other side, you need to make sure to go ahead and still file your answer. Even if you think that, okay, in principle, we've agreed, I just don't have anything in writing, file your answer. You don't want this to end up in a default. That'll transition the leverage as far as power and the ability to settle. Make sure that you file an answer. If the parties are agreeing to extend the answer, then you're going to want to file a stipulation. Have them sign off on it, you sign off on it, it's filed with the court. That way the court is aware of what you're doing, that the parties are negotiating and they want some more time for you to file your answer so that you don't end up with a default against you. It's important that all this is done in writing, that it's clear. If they're unwilling to do that, go ahead and file your answer just to be careful and to make sure you've got all your bases covered. If you look at the Consumer Warrior University, I have that down in the notes. We have a template tutorial. Also, Solo Suit, who's one of the sponsors of my channel, they have the ability to help you to draft an answer. It's not a big deal. It can be done very inexpensively, and get it done and get it filed. It'll save you a lot of aggravation down the road if you're not in the position to actually get the settlement done. The other alternative is if the lawsuit has been filed, and particularly if you're asking for a long-term settlement. Let's say you're being sued for $15,000 and they're saying, okay, we'll settle for $10,000. We'll take $5,000 off the top. And you're saying, look, I don't have 10 grand, but I can make payments of $250 a month. And they're gonna say, wow, that's a long time. We're not gonna leave this lawsuit pending for so long. Something you can offer is called a stipulated judgment. A A stipulated judgment is where an agreement is drafted, typically by the creditor's attorney, where you draft an agreement within the confines of a judgment that you're going to sign and that's going to be filed with the court. Now, the stipulated judgment, what it usually says is this. It says something like, look, you're agreeing to have judgment for the full balance. However, there's a settlement and you're agreeing to pay a reduced amount of $10,000 or whatever it is. You're going to be paying X amount of dollars per month. It usually has the date when it's due. And it states, as long as you're making those monthly payments, the creditor cannot execute. They can't collect on the judgment. It's called a covenant not to execute. And so as long as you're making those payments, they can't try to garnish your wages. They can't lien your house. They can't record it. They can't do any of these types of collections. However, there's a term in there that says if you stop making payments on it, if you stop doing the settlement as agreed, then they have their full judgment and then they can start collections. So this way it gives them the creditor some security of, look, we don't want to have to file the lawsuit again. We don't want to have to worry about the statute of limitations, but it is something where that it gives you the ability to make long-term payments. I've even had payments with creditors like American Express of 72, 84 months. You're able to make those payments, but it gives the creditor some security that you're unable to make the payment, that they can go and they have their judgment and then they can do collections. Most creditors will absolutely agree to that. You can put a term in there that no interest continues to accrue and that you're just basically paying this off. That can give you a lot of flexibility if you don't have a lump sum to get this resolved. Okay, so let's say you've entered the agreement, the paperwork's done. Let's go to the third area, which is some of the legal consequences and some of the little kind of tips and tricks that you need to be careful of. The first thing is, often the collector will say, okay, we will settle this and we'll agree to dismiss the lawsuit. If the lawsuit is dismissed, it needs to be dismissed with prejudice. A dismissal of a lawsuit with prejudice means it can never be refiled again. Sometimes the creditor will say, okay, we'll dismiss without prejudice. That's not sufficient. It needs to be dismissed with prejudice, meaning that it will never be filed again. But that alone is not enough. Now, I learned this the hard way early on in my legal career because we dismissed the lawsuit without prejudice. There were no settlement terms though. And then a year later, the creditor is contacting my client asking for payment. And I'm going, what are you talking about? We settled this thing. You agreed to dismiss without prejudice. They're like, we agreed to dismiss. There's no lawsuit. I believe even in that case, they dismiss with prejudice. They're like, we can't file a lawsuit, but we can voluntarily ask them for payment. So having them dismiss the lawsuit alone is not enough. You need to get them to agree and enter into that settlement agreement and provide you written acknowledgement that the debt has been eliminated, that it's been settled and it's done. That's an added protection that you're going to need to make sure that you don't run into that situation like I did, where even though the lawsuit's dismissed with prejudice, they can't sue you. They're still sending you letters and being annoying, that kind of thing. So you want to make sure that you have it in writing. Not only is the lawsuit dealt with, but everything else is dealt with completely as well. That's super important because I've seen that come back to bite people in a lot of situations. You want to make sure that you get that done. Now let's talk about two final things, credit reporting and a 1099-C. One of the big questions my clients will often ask me, okay, if we're going to settle this, I want this taken off my credit report. And I get that because that's going to give you a big bump if you can get this derogatory thing off your credit and you're in a better situation. Now, there is a law that kind of governs how credit reporting is done. It's called the Fair Credit Reporting Act, the FCRA. And often when we go to junk debt buyers, debt collection law firms, and we say, look, we want this thing to be settled, but as part of the settlement, you're agreeing to delete it from our credit report. Some creditors will press back against that. What their opinion is, and I have a little bit of sympathies for their opinion, not a lot, just a little, is that the Fair Credit Reporting Act states if a furnisher like them, if someone who's providing information to the credit reporting agencies like TransUnion, Equifax, Experian, if they're going to provide that to the credit reporting agency, to the credit bureau, it's got to be accurate. And so they say, look, we've got to report accurately, so we will update it to show that it's been settled, that there's a zero balance, that it's been settled. It'll usually have a notation there that'll say settled for less than a full amount owed. By the way, that won't happen. That update won't happen until you actually pay the full thing off. So if you're in a long-term settlement plan, it's going to stay on there at least, the 7 years plus that it's derogatory until you actually get it paid. But they say, so we'll report accurately, but we're not just going to delete it. Now, I understand that. And particularly for large debt buyers, they're dealing with a gigantic volume of cases, and they've got to be careful because they don't want to get sued by consumers, or they agreed to delete it and they didn't delete it, they just updated it, that kind of thing. I kind of get it. So some creditors will have a policy across the board that they're not going to delete. They'll just update it and report accurately. I always say you can press them on that issue, but I would not have that issue alone stop you from entering into a good settlement. If you think you can get this thing resolved, get it resolved, get it in the rearview mirror so you're not having to deal with it. They will update the credit report to show that it's been settled, that there's a zero balance there. That will benefit you in the long run, and you won't have to worry about it. But my response to their concern is saying, look, okay, I concede the FCRA, that Fair Credit Reporting Act, requires that you report accurately to the credit reporting agencies. However, there's no requirement that you report at all. All creditors report that voluntarily. You don't have to do this. They don't have to do it, period. So you will see some creditors who will agree for what they call pay for delete. You pay the settlement and then they'll delete that from your credit report completely. If they agree to that, make sure that you put a time frame in there as far as when that'll actually be paid or when that'll actually be deleted from your credit report so that you can make sure that you follow up. If they don't do that, then you can file a dispute through the credit reporting agency, and you may even have a potential lawsuit if they don't follow through with that portion of it. So that's important that you can press them on that issue and see if they're going to agree to get that thing deleted and off your credit report completely. The final thing I want to talk about is the 1099-C. Now, this thing is important to understand that anytime you settle a debt for less than what's owed, if the amount that is forgiven is more than $600, under the Internal Revenue Service Code, the IRS code, they are required to submit to you what's called a 1099-C. You typically receive these in January from the creditor. And basically what it is if they have to report anything over $600 forgiven, and you then have to treat that as potentially taxable income on your tax return the following year. So for example, let's say you have a $20,000 lawsuit. They agree to settle it for $8,000, so they've forgiven $12,000. You're likely to get a $12,000 1099-C that following year. You're going to have to report that $12,000 as a income on your tax return the following year. If it's a big one like that, if it's going to be a substantial amount, if we're talking $1,000 here or there, maybe it's not a big deal. If it's going to be a large amount that you're going to have to report, I highly recommend you use a CPA to file your tax returns, because there are ways around that, particularly if you're technically insolvent. If your debts outweigh any assets that you have, you may be able to avoid any tax liability, even with a 1099-C. So hopefully that helps you in kind of making your determination. At the end of the day, when you're dealing with a debt collection lawsuit, I always say there are many definitions of winning your debt collection lawsuit. It doesn't mean just that you win completely and that the lawsuit gets thrown out and they pay your attorney's fees. That's a great win. Those wins are they're less frequent than a really good settlement. And so if you get sued, don't panic, but maybe start thinking about, what could we realistically afford in the form of a lump sum or maybe a payment plan that could get this thing dealt with, get it off our plate, in the rearview mirror, and out of our lives forever. So hopefully that helps you out. If you are in the state of Arizona, or frankly any other state, check out the information below. We can help you. We have attorneys all over the country that we can refer you to. If you're in Arizona, I personally can help you. We'd be happy to see how we can help you with your debt collection lawsuit and get this thing out of your life for good. Thanks for watching today.